In this lesson of the VITA Basic Tax Law course, we will be learning about unique filing situations. More specifically, filing situations where some or all of the people on or potentially on the return are not U.S. citizens. In our last two courses, we learned about determining filing status and dependency, and we will be accessing and extending those two knowledge banks today. Let's start with where we will first get the indication that we are looking at a tax situation involving non-U.S. citizens. On our intake form, Form 13614C, there is a space in the Personal Information section, Part 1, where our clients will check if either they or their spouse, if filing joint, are a U.S. citizen. In Part 2, the section for Household Information, there are also some questions regarding the citizenship and residency of other people who either lived with our client or our client supported. Now remember, these are potential dependents of the taxpayer. We don't know for sure yet whether they will qualify to be on the return. We need to use the answers provided to the questions to determine this. So if our client has checked that either they or their spouse is not a U.S. citizen, we need to determine their alien status. They might be a resident alien or a non-resident alien. But before we move on, we need to understand why we are doing this, especially because for some of our clients, this process might be uncomfortable and feel invasive. We need to be sensitive to this and reassure them that our only purpose is to help them file an accurate return that provides them with all the tax benefits to which they are entitled. A resident alien will largely be taxed like a U.S. citizen, and that means they'll be taxed on worldwide income. And they may also be eligible for many of the same tax benefits that citizens would be. A non-resident alien, on the other hand, will be taxed only on the income that they earned in the U.S., or U.S.-sourced income, and they may be excluded from claiming many tax benefits. In order to determine alien status, we have two tests. And I know after we've had our dependence lesson, you're thinking, more tests? How am I going to remember all of this? Well, fortunately for us, Publication 4012 has an abundance of flowcharts. So if you're in the moment and you've forgotten how the test is supposed to go, look it up in your 4012 and it will lead you through the questions that you need to be asking the client to determine their status. So for alien status, our two tests are the green card test and the substantial presence test. The green card test is pretty straightforward. In this case, our client will have their card with them. It's roughly the size of a driver's license, and it will have been issued by the U.S. Citizenship and Immigration Services, and it gives them the privilege of residing and working permanently in the U.S. And most holders of this card will have a Social Security number. If our client does not have a green card, they might still be considered a resident alien for tax purposes. And in order to figure this out, we do the substantial presence test. And this is a formula of days and years that a person is physically present within the U.S. Before we start our calculation, though, they need to have been present at least 31 days in the current year or the tax year. If they've been present for at least 31 days, then we need to look at whether they've been present in this current tax year less than 183 days. And if that's the case, we start to look at if they've had a closer connection to another country. And a closer connection very often involves maintaining a residence in another country and the intent to return to that residence as main home. If our client has been present at least 31 days in the current tax year and they have no closer connection to another country, then we start our formula. And we are looking to get a threshold of 183 days or more spread out over the last 3 years. But the days in each of those years don't have the same weight. The current year, the tax year that we're looking at, those days get full weight. So you multiply the days present in the current year by 1. Moving back to the prior year, those days don't get quite the same amount of weight. So we multiply those days present by 1/3. Then we go back to 1 year prior to that, so our second prior year. Those days are weighted even less, and so we multiply those days present by 1/6. Once we get to those numbers, we total them all up, and if our client was in the US 183 days or more, they can be taxed as a resident alien. They will fill out Form 1040, and we can assist them with that. If, however, they have not been present for 183 days, then we would need to refer them out to a different preparer. They would need to fill out Form 1040-NR for non-residents. They would be a non-resident taxpayer. It is possible that some of our married clients will have a different status than their spouse. For a U.S. citizen or resident with a non-resident spouse, there are 3 options: filing jointly, filing separately, or there is a special exception that may allow the citizen or resident spouse to file as head of household, even though they are married. If they choose to file jointly, they elect to treat the non-resident spouse as a resident, and the worldwide income of both spouses will be taxed. If they choose to file separately, the citizen or resident will file Form 1040, and we can help them do that. The non-resident would need to file 1040-NR for non-resident if they are required to file, and we would have to refer them out for that because we don't file Form 1040-NR. It's out of our scope. Now, in order to file as head of household, the spouses would need to be filing separately. The taxpayer would need to be a U.S. citizen or resident for the entire year, so they could not have what's called a dual status. They have to meet all the other requirements for the status, so that includes like having a qualifying person as a dependent. And it's important to remember, a spouse is not a qualifying person. If the spouses choose to file jointly and it is their first year, they would need to make a special election in order to treat that non-resident spouse as a resident. In this case, they would be filing a paper return, and they would need to attach a statement signed by both spouses that says that one spouse was a non-resident alien and the other spouse was a U.S. citizen or resident on the last day of the tax year. It would also need to state that they choose to be treated as U.S. residents for the entire year. It would need to include the name, address, social security, or ITIN of each spouse, and then, of course, both signatures. Now, we should note that this statement, the preparation of this statement, is out of scope for our program. So we might be able to help them get their return put into the software, but ultimately they would have to print out that return and they would have to find a different preparer, a paid preparer probably, to help them craft that statement. Now, in future years, they can choose to file jointly or separately, and we can help with those returns. The agreement is only terminated by the revocation of either spouse, the death of either spouse, or their legal separation. And then it's possible that the IRS could terminate the election for failure to keep adequate records. Once we've determined the alien status of the taxpayer and or spouse, and they've decided what filing status choice they want to make, then we can start looking at other people who could be a dependent on the return. As we discussed before, one spouse cannot claim the other spouse as a dependent on the return, regardless of whether that other spouse is filing a U.S. return or not. They're just not a dependent ever. Then we have the case of a foreign-born child. And if at least one of the citizens is a parent, then yes, that child is considered a citizen for tax purposes and could be a dependent on the return. In the case of a foreign-born stepchild, we have a little more complication. If that foreign-born stepchild is a resident alien, then yes, that child could be a dependent on the return. If that foreign-born stepchild is a resident of Canada or Mexico, they can also be considered a dependent on the return. If, however, that foreign-born stepchild is a non-resident alien, then no, they would not be able to be on the return. In the case of a foreign-born adopted child, if that child lived with the taxpayer all year, has a social security number, an ITIN or an ATIN, then yes, they can be on the return. There are a lot of areas of this topic that are out of scope for our program. Taxpayers with F, J, M, or Q visas, and those are usually your temporary workers or your foreign students, are out of scope for our program. Also, non-resident aliens who do not meet the green card or substantial presence test, and they are not married to a U.S. citizen or resident alien. If you remember, the form that they would be filling out is Form 1040-NR for non-resident, and we do not provide services for that form in our program, so that is out of scope as well. For individuals who this is their first year in the country, they might have what's called dual status. So for part of the year, they might be considered a non-resident alien, and for the other part, they might be considered a resident alien. And in that case, we won't be able to help them this year, maybe next year. And then, of course, as we discussed before, the required statement for the non-residents who are married to a U.S. citizen or resident, and they're on that first year making that election to file a joint return, we can't do the statement for that. And remember, if you get stuck figuring out the alien status of a client, or if you're looking at a problem on the test even, we have our resources. Publication 4012 tab L is all about non-citizens, and there is a decision tree in there and a decision chart that go over those questions that we talked about, and you follow the flow of it, and in the end you figure out the status. There are also some publications. You can get them on the IRS website. Publication 519 and publication 54, those are going to be more extensive than our resources. If you look at those, you'll get a lot of great information, but remember, we do have scope, and they will tell you how to do things that are out of our scope. So just make sure that when you are performing services, that you are only doing things that are within our scope. And then there's the interactive tax assistance, can help with the filing status decisions and the dependent decisions, and that's at irs.gov.